And for those patent trolls and some people out there who get patents that are somewhat questionable, when they start picking on the small fish, they usually get away with it and get some licensing fees out of it. When they start picking on the really big boys who have the war chest to take them on, a lot of times what will happen is there'll be a challenge at the patent office to re-examine that patent, and they'll fight to invalidate it. And that happened, like for example, when Y2K was around, there was a guy who claimed he had a patent on the Band-Aid windowing for saying that for computer programs that were all written with 2 digits, that he wrote a program that said if it's 00 through 49, put a 20 in front of it. If it's 51 or 50 to 99, put a 19 in front of it, which delayed the Y2K problem for 49 years, which is fine because any system around here is going to be completely obsolete by 2049. But he claimed that, and he got a patent issued on it. Well, when he started trying to enforce it, it got attacked for obviousness, and the courts ultimately agreed and validated the patent.
To what extent is an algorithm patentable as a product?
Not.
Well,
not a pure mathematical.
No, pure math is not patentable in and of itself. But when you talk about algorithms, maybe steps in a particular process for a business method, yeah.
Software, so not necessarily math, but
yeah.
the process of.
Sure. No, and that's where business method patents come into play. And so, business method patents. There were a lot of folks that were taking a little bit of a side tour. There were a lot of folks that thought the In re Bilski case would sort of limit the ability to seek patents on some of those types of algorithm related patents. The Supreme Court sort of declined to challenge that. And so, what you actually found is that a lot of those can still make their way through the patent office. So things like algorithms that form sort of the secret sauce of the underlying, the important processes within your software very well may be patentable. Yeah. So, yeah. Let's continue on. I know we've got a lot to cover here. So just sort of continuing on. What does IP not protect? I think this comes as a shock to a lot of folks that reverse engineering of software isn't a violation of IP law within the United States. So breaking DRM protection might be, but merely reverse engineering isn't protectable. So what's one of the first things that you would put in any license agreement? Do not reverse engineer is, I think, one of the most common provisions that you see in any license agreement for receiving code in object code format. So that's one of the things. Prohibitions against assignment is another tricky area. So let's say I give to Dean, my latest and greatest software product, and I say to Dean, take this software product. It'll do everything. It'll tie your shoes. It'll, it'll make you younger, smarter, faster. Get you on Glee, and it will, you can use it, and it'll do great things for you. Dean says, uses it for a year. He gets on Glee. He gets his next recording contract. He says, I don't need this anymore. This is great. I'm going to give it to Yermo. Yermo wants to get on Glee. He's
for a small price.
That's right. That's right. Well, the thing that if I gave Dean this code and it got him everything he wanted, and he wanted to assign that to someone else, he very well may have the right to. And I, as the original licensor of that code, may not have the ability to prevent him from doing so unless I have a contractual prohibition preventing him from giving it to Yermo. So that's one of the things to keep in mind, is that when you are giving out your technology, when you are granting a license to your technology, it's important to have appropriate provisions in there regarding assignability of that. The other thing that IP doesn't protect against is, let's say I give my wonderful software to Dean. Dean takes one look at it. He starts tinkering with it. He says, this stuff is terrible. You know what, Sanjay? I'm going to sue you. I'm going to sue you because this stuff is terrible. I didn't get on Glee. You know, Rachel wouldn't talk to me. It was, you know, it was awful. And so he turns around and sues me. Well, unfortunately, there's nothing under IP law in and of itself that would protect my liability if I had, in fact, in certain jurisdictions, merely by the fact of me giving Dean that code, there might be certain implied warranties regarding the operability of that software. And unless I disclaim that liability, unless I said to Dean, you know what, all you can get from me is the $5 you paid me for it, you know, he very well may have a claim against me in those circumstances. So that's one thing to keep in mind, is that in your contractual provisions, you want to make sure that you've got terms that protect your liability as the ultimate licensor.
And when you say contractual, you mean the license agreement for the software that an end user might have to agree to, which binds them to all of these rules.
Absolutely, absolutely. And I think we've all done that multiple times. I mean, you know, we've all hit the I accept button on.
So
how many folks read that, by the way? I'm just curious. Very, very good.
More
Very
importantly, out of the mobile app developers here, how many have license agreements in their apps that people have to agree to before installing or using the apps? Show of hands?
Yeah.
Something to think about.
There's a few clients of mine in the audience who should be raising their hands.
Absolutely, absolutely. No, and Guillermo, thank you for that, because that is an important point. I mean, to the extent you're working in the iOS platform, you know, Apple does have some protection through its terms, but it's not nearly the protection that one gets from having your own terms that pop up in your own software. So,
yeah, because we should remember to always bring it back to, you've got somebody who's got no background in this subject. They've got the idea on the back of the napkin.
Yep.
They've built some code. What next?
Yeah.
Well, actual bit of intelligence. An actionable thing you can do is make certain you have a license agreement written by a competent attorney to cover the rights that intellectual property does not cover for you.
So
Right?
that,
For example, if you have a mobile app that's GPS connected, somebody in the audience here does. GPS
I heard an audible
connected.
groan from somebody in the audience.
and somebody follows that app and drives through some storefront plate glass window and runs over a bunch of school children on a field trip in the store. You could be liable for all of that because your GPS app failed and gave bad directions.
Well,
so I mean, what you want to do is limit, and a lot of it's very important when especially when you have software that's being sold out for end users, not just mobile apps, but software that's sold out there, software applications to run on computers and things like that. That there's strong disclaimers and bold, large caps, basically saying that you're not liable for any special damages, punitive damages, exemplary damages, and limiting it, as Sanjay said, limiting it to at most the amount of purchase price revenue that the licensor took from the licensee.
Yeah, I think these are
risk allocation issue.
Yeah, it's absolutely a risk allocation issue, and these are some things to be considering, particularly if you think about your application as having a lot of different functionalities, a lot of different real-world applications. Just remember that the more uses, the more potential uses for your app, the more potential claims for liability you might be exposing yourself to. So always advisable to do what you can to limit your liability in those circumstances. So, just sort of iterating on some of those points, just always remember, and I think folks forget, given the ease of downloading, the ease of accessibility, that mobile apps are software. And just like any other software, you often want to impose licensing terms on those. You do want to have licensing terms that limit your exposure, limit your liability. The other problem to avoid is how many folks, well, I don't know if folks will want to answer this question. Feel free not to if you don't want to. But how many folks have pulled a license agreement or pulled another agreement off the web and used it in your business, just sort of as is? I see a few hands. Yeah, I see some hands go up, and sometimes that's perfectly fine as long as you have a good understanding of what that license agreement entails. But what I'll tell you, we often see folks pull agreements, terms off the web, maybe from some of their competitors, maybe from some of their other locations, maybe from partners that they've worked with in the past, maybe from prior businesses that they've worked at in the past. And often what will happen is there will be terms in there that will come back to bite them, that won't be applicable to the business, that will have been specially tailored for that particular type of business. And so one of the things to keep in mind is that it is important to make sure that the terms that you have with your partners or with your licensees or with your distribution channel, that the terms that you have in there simply reflect your business. You want to make sure that there's no more and no less in that agreement than what you need for your business, and that's often lost on folks that are pulling down form agreements. So just something to keep in mind. One of the things I mentioned, yeah.
I'm selling a piece of software, not for mobile, but for use on a PC.
Sure.
And it's got an instruction manual, and the first page of the manual is the agreement.
How enforceable is that?
Yeah, I think I have to go back and look at it. I think there's language that says, by software you agree to this, but do they have to sign something or
Yeah.
actually do something?
That's a great question. So, the question for those that didn't hear it was, if I've got an instruction manual and it's got my license agreement on that first page, and maybe there's a sticker that says by opening this box or by installing this you agree to those license terms. How enforceable is that? Really, it comes down to one of contract formation. It's in order to have an enforceable contract with somebody, you need to have assent to that contract. And so if in the process of, say, installing the software, there's an I accept button and I accept, the terms and conditions that are listed in the instruction manual, you could have a good case there. Now, some states, what you were talking about is what we would call sort of a shrink wrap set of license terms. That there are terms that are sort of in the box. You may not you may not necessarily need to accept anything to see them. Sometimes that can be a challenge, and those have been challenged on occasion if there is no assent procedure that goes along with those terms. It's much more advisable to have a sort of click-through set of terms. I think we've all seen those where you hit the sort of I accept button and move on. Now, Virginia and Maryland are actually two states that have adopted what is known as the Uniform Computer Information Transactions Act, which actually has in it provisions that say if you have a double assent procedure in your acceptance of terms. So, for example, if you have an I accept box that you also have to put a check mark and then hit next. If you have that double assent procedure, the courts in the state and courts enforcing those terms will assume assent if somebody has gone through that step. So yeah, that's something very important to keep in mind, is that you do want to have you don't simply want to rely on terms within the box or terms that are available somewhere on a website. You do want to get some sort of assent procedure in that.